So good afternoon, class. So I'm sorry, but for today, I won't be able to meet you face to face because I'm currently on our mock city and I won't be able to go back to Tacloban City on time. However, because you have your exams next week, we have to finish our discussions to the very least until the very last paragraph of justifying circumstances, which also directly implies that the coverage for your upcoming exam will include all topics already discussed, especially in the general provisions of criminal law, general characteristics of criminal law, general principles, and until justifying the end, hopefully, the end of justifying circumstances. So, whatever topics that we will be able to finish this afternoon will be included in your exams. Okay. So now let's move on to our next topic. We already discussed self-defense exhaustively yesterday. So for today, we will be discussing all the other justifying circumstances. Okay. Justifying circumstances available in the revised penal code. Let's go to the second paragraph, which which is anyone who acts in defense of the person or rights of his spouse, ascendants, descendants, or legitimate natural or adopted brothers or sisters, or of his relatives by affinity in the same degrees, and those by consanguinity within the fourth civil degree, provided that the first and second requisites prescribed in the next preceding circumstances are present, and the further requisite in case the provocation was given by the person attacked that the one making the defense had no part therein. So this is a very long provision and it is actually just how many sentences? It's one sentences. So just by reading it, somehow you lose your breath, right? But to be able to fully understand this provision, you have to divide it according to parts. Number one, this provision refers to defense of relatives. Okay, so first we have to discuss who are considered as relatives because so that it can be considered as defense of relatives, then the person being defended is actually should be a relative. So your relatives will include your spouse, ascendants, your parents, descendants, your children, legitimate natural or adopted brothers and sisters or relatives by affinity in the same degree. So meaning your brothers and sisters and your brothers-in-law and sisters-in-law and relatives by consanguinity within the fourth civil degree. So relatives by affinity, again, because of marriage, are parents-in-law, son and daughter-in-law, and brother or sister-in-law. So they are also included. Okay. So, what are the requisites of defense of relatives? Of course, the very first one, you have your unlawful aggression. It's also a very important requisite. Just like in self defense, it is also a condition sine qua non, which means it is a requisite. Okay. In the absence of such requisite, then it will not be justifying, but may be considered as a mitigating circumstance. Second, reasonable necessity of the means employed to prevent or repel it. So we've already discussed this yesterday. Now, it is not required that there is equivalence in the blow, okay? In the blow. But what is required is that there should have been that at the time that the means employed was used, there was still unlawful aggression. So you have to consider the age of the victim, the health of the victim, the position of the victim, the number of blows, for example, stab wounds, gunshot wounds, the location of the wounds. So from there on, you will see whether it was just a mere defense or there was really intent to kill. Okay. So number three, in case the provocation was given by the person attacked. So we have to determine who is the person being attacked here. So those are your relatives. So when you refer to the person being attacked, you go back to this five. It's either your spouse, your wife, or your husband was being attacked, your ascendant, or the descendant, the legitimate, natural, or adopted brothers and sisters or relatives by affinity in the same degrees, relatives by consanguinity within the fourth civil degree. Okay, so it only means that even if they were the one, so in self-defense, there should have been no sufficient provocation on the person defending himself. But here, in defense of relatives, there could be provocation on the part of the relative being defended. However, the one making the defense should not have participated in the provocation. Okay? So even if the relative was the one who started the altercation, the relative was the source of the provocation, so long as the person who made the defense did not participate in the provocation itself, then uh, the defense of relatives doctrine can be raised, okay? And could be considered as a justifying circumstance. Okay? So I hope that is clear. So what is the rationale on defense of relatives? So in sorry, in self-defense, if you can still remember, the rationale there is that the government cannot monitor all the activities of its citizens 24/7. So every citizen is given the opportunity to defend themselves. But here, what about for defense of relatives? What is the rationale behind that? The justification of defense of relatives by reason of which the defender is not criminally liable is founded not only upon a humanitarian sentiment, no, but also upon the impulse of blood, which impels men to rush on the occasion of great perils to the rescue of those close to them by ties of blood. So the law also recognizes na kung kamag-anak mo, kadugo mo, iti mo dito instinct is bumulig, no? Umapi. So that's why, no, it's amazing how the law realizes how the law uh realizes that we are mere human beings and we have impulses, no? So that is the rationale behind that. Next. So we have examples here of defense of relatives. Number one, the accused at a distance of about 20 brasas from his house heard his wife shouting for help. No, nabatian niya ni asawa nga naguli at naarin bulig. He rushed to the house and once inside saw the deceased meaning the victim here, on top of his wife. Okay? On top of his wife. So bagang ginlulugo sa niya asawa. He drew his bolo and hacked the deceased at the base of his neck when the latter was forcibly abusing his wife. So, kanina tigbas niya hamay hamay liog. So, of course, the blow haliog, it could be fatal, diba? Kay liog gud iton. So, but it was still considered as an act of self-defense because what? There was unlawful aggression being made on his wife. It was reasonably necessary because halos ginerape na nga niya niya asawa. Diba? Number three, there was no unlawful aggression or even if there was, sorry, even if there was no sufficient provocation. But even if there was sufficient provocation made by the wife, no, so long as the person who killed the victim did not participate in the sufficient provocation, then it is still a valid defense. Okay? In a justifying circumstance. Number two, Domingo Rivera challenged the deceased to prove who of them was the better man. When the deceased picked up a ball and went after him, Domingo Rivera took to flight, dumalagan. The deceased pursued him and upon overtaking him, inflicted two wounds. So, Domingo Rivera. Antonio Rivera, father of Domingo, rushed to his son's assistance and struck with a cane the bolo from the hands of the deceased. Domingo Rivera inflicted fatal wounds upon the deceased. While the son was originally at fault for giving provocation to the deceased, yet the father was justified in disarming the deceased, having acted in lawful defense of his son. But Domingo Rivera was declared guilty of the crime of homicide. So here, no, there was sufficient provocation coming from Domingo Rivera because hiya nga ni an nagtikang no hiya ginayat an ah iya ginayat ang victim here, ang victim here nga ito kung hino erat mas makaret hino't mas lalaking lalaki, no, the deceased here. And Antonio Liwat, upon seeing that his son was being attacked, iya gindisarm gamit an iya cane, gindisarm niya ang bolo didto han victim, the deceased, no? So, yes, the act of the father upon seeing his son being attacked by another person is a valid defense, no? A valid defense of relative. However, on the part of Domingo Rivera, who started the provocation, he was actually, on his part, defense of relative that did not apply because in the first place, he was the one who what? Who made the provocation first. Okay? So the father here was justified, but the son who challenged the victim still na kasuhan lagi and na-convict lagi hiya for crime. So this is from the case of US versus Rivera. Okay? So I hope that is clear. I hope naiintindihan niyo. But anyway, should you have any questions, I'd be happy to answer them later. I will be posting, no? I will be posting our attendance. I hope you can send your questions there so I can answer them one by one. Number three, anyone who acts in defense of the person or rights of a stranger, provided that the first and second requisites mentioned in the first circumstance of this article are present and that the person defending be not induced by revenge, resentment, or other evil motive. Okay? Anyone who acts in defense of the person or rights of a stranger, provided that the first and second requisites mentioned in the first circumstance of this article are present and that the person defending be not induced by revenge, resentment, or other evil motive. So this one, the first paragraph refers to self-defense, the second paragraph refers to defense of relatives, the third paragraph refers to defense of strangers. So what's defense of strangers? So who are deemed strangers? Now, any person not included in the enumeration of relatives mentioned in paragraph 2 of this article is considered stranger for the purpose of paragraph 3. So we already have an enumeration who are considered as relatives, okay? So for purposes of paragraph 3, whoever is not included in paragraph 2 are strangers, okay? Hence, even a close friend or a distant relative is a stranger within the meaning of paragraph 3. So even if you say that you are a brother from another mother, sometimes you are more close to your friends than your actual siblings. Still, they are considered as strangers. Even if you've been with them from the very beginning, you were born together, you've lived together, you have what? You grew up together, you were raised together, you consider each other brothers and sisters. But if he or she is not one of those enumerated in paragraph 2, that person is still considered as a stranger under the law. Okay? So, example, A heard screams and cries for help. When A responded, he saw B attacking his wife with a dagger. So, B is the husband and the wife is here being attacked. A approached B and struggled for the possession of the weapon, in the course of which A inflicted wounds on B. So what was the decision here? The court A acted in defense of a stranger because uh uh the wife is not a relative, not one of those. The wife of B, not related to A, is not one of those considered as a relative in paragraph 2. So okay, I hope that is clear. So, what is also important that the person defending be not induced by revenge, resentment, or other evil motives. So, for example, you had a very close friend, but that friend, not considered as a relative under paragraph 2, although you are very, very close, still is considered as a stranger. And then, your friend was attacked by another person. Gingkastigo hiyahin usa nga tawo. No? And you, gusto mo bumulos, gusto mo mag-revenge, gusto mo magkamayan ng vengeance. Kung madto ka haira, gin kastigo mo liwat ito hiya nga tawo nga nagkastigo ni masangkay. Is that still defense of strangers? No, because you are already as making the defense, you are already motivated, no, by revenge, no, and resentment. And you are not acting on impulse anymore. Imo na hayagin pursue, kumadto ka pagud haira balay haira lugar. Okay? So I hope that is clear, ha? You should not be induced by revenge, resentment, or other evil motive. Okay? Next, paragraph 4, avoidance of a greater evil. Any person who, in order to avoid an evil or injury, does an act which causes damage to another, provided that the following requisites are present: that the evil sought to be avoided actually exists. It's not just imaginary. Kay nasin ka na, yung patay ko na lang kay nahadlong ba na ko nga patayon ako niya, kay may ako niya gintatarhog. So, the evil sought to be avoided, it does not actually exist. It is still imaginary. So you cannot act upon it. Second, that the injury feared be greater than that done to avoid it. Okay? So, the injury feared, ano imo kakahadlukan nga mahinabae mo, dapat mas hataas siya kaysa imo nabuhat nga sala. Like for example, nahadlok ka lang nga masakitan ka, but in turn ginpatay mo siya kay nahadlok ka nga pasakitan ka niya. No, so no, the injury feared must have been greater. That there be no other practical and less harmful means of preventing it. Okay? So example, a person was driving his car on a narrow road with due diligence, take note ha, and care when suddenly he saw a 6x6 truck in front of his car. If he would swerve his car to the left, he would fall into a precipice. No? Or if he would swerve to the right, he would kill a passerby. He was forced to choose between losing his life in the precipice or sacrificing the life of an innocent bystander. He chose the latter. Ano niya ginpili? Kumadto na lang hiya, ha? Alright. Napatay niya and passerby. The latter swerved his car to the right, ran over, and killed the passerby. In view of this example and the principle involved, okay. The killing of the fetus to save the life of the mother may be held excusable. So, amo lagi ito may nakita mga sinesali nga abortion nga natatabo. Some abortions are legal, especially if the mother is suffering from an ailment which would render the pregnancy a danger to the mother. For example, ectopic pregnancy. Ectopic pregnancy, natatabo ito hiya pag iton ovum na implant outside of the placenta. No, it's very dangerous to the mother, and also the fetus will not survive kaya outside nga niya at placenta will not have sufficient nutrients. So the doctors will have to choose whom to save, and normally they would always choose to save the mother. Okay, kay yun, the existence of the fetus, although clinically it's already considered as having life inside the womb of the mother, nonetheless they have to choose between the death of the mother and the fetus. And yes, if there is induced abortion, no abort ito hiya nga pregnancy because of that condition, then it is not one of those considered as criminal abortion, criminally prohibited abortions. No, it could be considered induced abortion by reason that it is to save the life of the mother. Okay? So, I hope nakaklaro ito ninyo. Number 5, fulfillment of duty or lawful exercise of the right or office. Any person who acts in the fulfillment of a duty or in the lawful exercise of a right or office No, so number one, that the accused acted in the performance of a duty or in the lawful exercise of a right, or that the injury caused or the offense committed by be the necessary consequence of the due performance of duty or the lawful exercise of such right of office. Now, so example, People versus Felipe. So facts, Lorenzo Napilon escaped from the jail where he was serving sentence. Some days afterwards, the policeman Felipe de Lima, who was looking for him, found him in the house of George, armed with a pointed piece of bamboo in the shape of a lance, and demanded his surrender. The fugitive answered with a stroke of his lance, gumbabalbagan in the shape of a lance, bagan kon niya gihapon, bagan sundang ba. The policeman dodged it, and to impose his authority, fired his revolver Pusil at policeman, but the bullet did not hit him. The criminal ran away without parting with his weapon. The peace officer went after him and fired again his revolver, this time hitting and killing him. No, the policeman was tried and convicted by the court of first instance of homicide and sentenced to temporal and the accessory penalties. So what was the decision of the Supreme Court here? Kay Court of First Instance pa man lang niya conviction. Pwede pa sumakak Court of Appeals, Supreme Court. So what was the decision of the Supreme Court? The killing was done in the performance of a duty. The deceased was under the obligation to surrender kay kung bayahiya, detained bayahiya, escape lahiya, and had no right after evading service of his sentence to commit assault and disobedience with a weapon in his hand, which compelled the policeman to resort to such to an extreme means which, although proved to be fatal, was justified by the circumstances. So the policeman was just left with no other recourse but to fire, di ba? To fire the gun. Kay, ato na lagi. No? Article 8, number 11 of the Penal Code being considered, Felipe de Lima committed no crime. Sorry. Section 8, Article number 11. Felipe de Lima committed no crime and he is hereby acquitted with costs the official. Okay? So, paragraph 6, obedience to an order issued by some for some lawful purpose. Okay? Any person who acts in obedience to an order issued by a superior for some lawful purpose. Okay? So that an order has been issued by a superior, that such order must be for some lawful purpose. Kay kung nimo superior, ginsugo ka nga pagpatay, pangidnap, that's not lawful. Okay, you will never be justified for doing something illegal in the first place. No, that the means used by the subordinate to carry out said orders is also lawful. So number one, there is an order of a superior. Second, that such order is lawful. And number three, that the means employed is also lawful. Okay? So, for example, ginsugo ka nga ah, mag mag ah, mag-seize in property. So, may the search warrant. Pero diri mo pa nimo ka-execute diri although bisan lawful an order had imo superior to execute the search warrant, but then you did not follow the search warrant, di ba? There are specific the search warrant will issue describing the place to be searched and the items to be seized. But then in serving the search warrant, you seize the items not included in the search or in the warrant itself. And those items are not even prohibited. For example, kumita ka kwarta dito. No, but it was not included in in the search warrant. But still, you seized the the monies that were there during that time. Then it is not lawful. Okay? The means that was employed to seize the items are not lawful. Okay, so I hope that is clear. Kay bangin na may nalilipat ka mo nga bisan ano masaring man, 'di ba nga, you always follow the orders of your superiors, but that is not true. First, you also have to determine whether the orders of your superiors are actually what? Are actually lawful. Kay diri tanan nga ginsusugo kay masaring obey first ko, no? Pero not in all circumstances because you also have to what? You also have to understand that there are specific rules in the law for your actions to be justified. Okay? So again, as a review on justifying circumstances, the first one is self-defense. So the requisites are unlawful aggression on the part of the victim. Huh? Second, reasonable necessity of the means employed to prevent or repel it. Third, lack of sufficient provocation on the part of the person defending himself. Number two, defense of relatives. Anyone who acts in defense of the person or rights of his spouse, ascendants, descendants, or legitimate, natural, or adopted brothers or sisters, or of his relatives by affinity in the same degrees, and those by consanguinity within the fourth civil degree, provided that the first and second requisites prescribed in the next preceding circumstances are present. And the further requisite in case the provocation was given by the person attacked that the one making defense had no part therein. Okay? So I hope you understand fully the word the meaning of these provisions. Number three, anyone who acts in defense of the person or rights of a stranger. So in defense of strangers, provided that the first and second requisites mentioned in the first circumstances, of course, unlawful aggression, reasonable means employed to prevent or repel it. But in number three, the third requisite here is that the person defending be not induced by revenge, resentment, or other evil motive. Number four, any person who, in order to avoid an evil or injury, does an act which causes damage to another, provided that the following requisites are present. No, first, that the evil sought to be avoided actually exists. Dari imaginary, dari ginunahunaan mo la that it is imminent or impending. Second, that the injury feared be greater than that done to avoid it. Okay? So there would have been greater injury had you not chosen, no? To had you not chosen to use the lesser evil means. So igwiwi mo hiya, no? That there be no other practical and less harmful means of preventing it. You had no other choice but to do it, to do such damage because it was the only way, no, the only way that you could save yourself. Any person who acts in the fulfillment of a duty or in the lawful exercise of a right of office. Okay? And but take note ha, mga police officers, you always have to exercise maximum tolerance. The use of firearms is always the last resort. Kung di rin man ito nanlalaban, agoy, ayaw good ka mo paggamit ng firearms because pwede ka mo balikan. Pwede ka mo pa mismo kakasuhan. Number six, any person who acts in obedience to an order issued by a superior for some lawful purpose. So that ends our discussion on justifying circumstances. But we need to have a review because as I mentioned earlier, you will be having your um, exams next week. So I need to conduct a review. Okay, I need to conduct a review um on the things that we have already discussed in the past. Okay, so first let's discuss let's discuss the constitutional rights of the accused. Why is this important? Yeah. The constitutional rights or the constitution, being the highest form of law in the land, should always be what? Should always be followed. Okay? So it's very important if you want to become a law enforcer, it's always very important that you know these doctrines. So under the Constitution, all persons shall have the right to a speedy disposition of their cases before all judicial, quasi-judicial, or administrative bodies. These are constitutional rights, okay? Number two, no person shall be held to answer for a criminal offense without due process of law. That's why we cannot have, we have the limitations, diba, on bill of attainder, ex post facto law. Number three, all persons except those charged with offenses punishable with reclusion perpetua when evidence of guilt is strong shall before conviction be bailable by sufficient sureties or be released on recognizance as may be provided by law. The right to bail shall not be impaired even when the privilege of the writ of habeas corpus is suspended. So you have bail, you can have bail as a matter of right, meaning you don't have to file a motion to post bail if the penalty, the imposable penalty of the crime charged is lower than reclusion perpetua. But if it is reclusion perpetua, you can the remedy of bail is still there, but then you have to file a motion to post bail, and now it is discretionary upon the court whether you will be allowed to post bail. Okay? So that's the difference on that. So in all criminal prosecutions, this is a very important concept. The accused shall be presumed innocent until the contrary is proved, and shall enjoy the right to be heard by himself and a counsel, to be informed of the nature and cause of the accusation against him, to have a speedy, impartial, and public trial, to meet the witnesses face to face, and to have compulsory process to secure the attendance of witnesses and the production of evidence in his behalf. However, after arraignment, trial may proceed notwithstanding the absence of the accused, provided that he has been duly notified of his failure to appear and his failure to appear is unjustifiable. Okay? So again, the accused shall be presumed innocent unless contrary is proved. Okay? And he has the right to be informed of the accusation raised against him. Number 5, no person shall be compelled to be a witness against himself. Okay, so this is the right against self-incrimination. Any person under investigation for the commission of an offense shall have the right to be informed of his right to remain silent and to have competent and independent counsel, preferably of his own choice, especially during custodial investigation. If the person cannot afford the services of a counsel, he must be provided with one. These rights cannot be waived except in writing and in the presence of counsel. Take note again, this is your Miranda doctrine. No torture, force, threat, intimidation, or any other means which vitiate the free will shall be used against him. Secret detention places, solitary, incommunicado, or other similar forms of detention are prohibited. Any confession or admission obtained in violation of this section hereof shall be inadmissible in evidence against him as what? Fruit of the poisonous tree. So it will be what? It will be inadmissible in court. Number 6, excessive fines shall not be imposed, nor cruel, degrading, or inhuman punishment inflicted. No person shall be put twice in jeopardy of punishment for the same offense. If an act, but if an act is punished by a law and ordinance, conviction or acquittal under either shall constitute a bar to another prosecution for the same acts. Okay? Free access to the courts and quasi-judicial bodies and adequate legal assistance shall not be denied to any person by reason of poverty. So those are your constitutional rights. Now let's go to your statutory rights. Number 1, to be presumed innocent until contrary is proved beyond reasonable doubt. Okay, take note, guilt beyond reasonable doubt. To be informed of the nature and cause of the accusation against him. So the defendant or the accused actually has the right to be informed. Okay, ginaakusaran ka, no, pagpatay or pangawat, no. Number 3, to be present and defend in person and by counsel at every stage of the proceedings from arraignment to promulgation of the judgment. But of course, this is a right, no, to be present. So if you don't want to attend the hearings, you just want your counsel to be there, then it's okay. No? Number 4, to testify as a witness in his own behalf, but subject to cross-examination on matters covered by direct examination. His silence shall not in any manner prejudice him. So, as a constitutional right, silence, iniya nga mo concept na silence means yes, there ito na apply. No? Even if he is not silent, even if he is silent and he does not interpose any defenses, what is the doctrine here? The prosecution must rely upon the strength of their evidence and not on the weakness of the defense. take note. So it is the job. It is the job of the prosecution to what? To prove guilt beyond reasonable doubt. Except, except when when the defendant or the accused raises justifying circumstances, accepting circumstances, mitigating circumstances, because now the burden of proof will be shifted to the defendant. Okay? To be exempt from being compelled to be a witness against himself. So if he wants to be a witness for his own behalf, of course he can do that. But he cannot be what? He cannot be forced to be a witness against himself. Number six, to confront and cross-examine the witnesses against him at the trial. Okay, so he must be given the opportunity to question, okay, and to confront the testimony of the witnesses during trial. But it's up to him, okay, it's up to him if he will exercise such right. Number seven, to have compulsory process issued to secure the attendance of witnesses and production of other evidences in his behalf. All these are available in the rules of court. Okay. Number eight, to have a speedy, impartial, and public trial. Number nine, to appeal in all cases allowed and in a manner prescribed by law. So we have appeal, no? If you, that's the problem because in criminal law, if you get convicted, you can appeal it. No, you can appeal it to a higher court. However, if guilt is not proven beyond reasonable doubt, or the defendant gets acquitted, you can no longer appeal. No, because it will now tantamount to what? To double jeopardy. So, okay, again, going back, if it's conviction, you can appeal until the Supreme Court. But if it's an acquittal, you can no longer appeal that, bounded on the principles of double jeopardy. Okay? So also, please take note of the characteristics of criminal law. We have generality, um, territoriality, prospectivity. So we've already discussed that. Okay? We've already discussed this several times. I think we don't have to discuss this any further. Kakadamo na ito natin ginbalik-balik. Okay? And of course, the theories of criminal law, we have the classical, which provides that human beings no have the free will, and and that's why they should be imposed with penalty, because they have human beings have the free will. We always have the free will to choose between good and evil. Okay, and uh s- Article 2 on the application and the territoriality. Number one, when the offender should commit an offense while on a Philippine ship or airship. Oh, okay. So a Philippine vessel or aircraft must be understood as that which is registered in the Philippine Bureau of Customs. It is the registration of the vessel or aircraft in accordance with the laws of the Philippines, not the citizenship of its owners, which makes it a Philippine ship or airship. So even if it is German owned, or the owner of the vessel is French, European, American. If the ship is registered here in the Philippines, it is considered as a Philippine airship. Next, the Philippine vessel, although beyond 3 miles from the seashore, is considered still part of the national territory. Thus, any person who committed a crime on board a Philippine ship or airship while the same is outside of the Philippine territory, can be tried before our civil courts for violation of the penal laws. So when the offender should forge or counterfeit any coin or currency note of the Philippines, or obligations and securities issued by the government, thus any person who makes false or counterfeit coins, or forges treasury or banknotes or other obligations and securities in a foreign country, may be prosecuted before civil courts for violation of Article 165, 166 of the Revised Penal Code. when the offender should be liable for acts connected with the introduction into the Philippines of the obligations and securities mentioned in the preceding number. So the reason for this provision is that the introduction of forged or counterfeited obligations and securities into the Philippines is as dangerous as the forging or counterfeiting of the same to the economical interest of the country. So naghimo ka man or kung gingamit mo lang ini nga mga securities and obligations, the same effect. It affects the Philippine economy. Okay? So number 4, when the offender, while being a public officer or employee, should commit an offense in the exercise of his function. So the crimes that may be committed in the exercise of public functions are direct bribery, indirect bribery, no? Possession of prohibited interest, malversation of public funds or property, failure of accountable officer to render accounts, illegal use of public funds or property, failure to make delivery of public funds or property, falsification by a public officer or employee committed with abuse of his official function. When any of these felonies is committed abroad or any of our public officers or employees while in the exercise of his duty, he can be prosecuted here in the Philippines. Okay? So those are uh, offenses in relation to governmental functions. So when the offender should commit any crimes against the national security and the law of the nation. So the crimes against national security and the law of nations are, of course, number 1, treason, conspiracy and proposal to commit treason, espionage, inciting to war and giving motives for reprisals, violation of neutrality, correspondence with a hostile country, flight to enemy country, and piracy and mutiny on the high seas. The crimes committed outside of the Philippines but punishable therein under Article 2 of the Revised Penal Code shall be cognizable by the regional trial court in which the charge is first filed. So, bisan di in the Philippines, you can file it through the regional trial court. However, if you file it in one regional trial court, all the other courts are already excluded. If you file for a specific act, you file it in the regional trial court in Cebu, then you cannot file for the same act in a regional trial court in Manila. Okay? So to the exclusion of all other courts. Regional trial courts have original jurisdiction over all crimes and offenses committed on the high seas or beyond the jurisdiction of any country on board a ship or warcraft of any kind registered or licensed in the Philippines in accordance with its laws. Okay? So, crimes committed on board foreign merchant ship or airship. Just as our merchant ship is an extension of our territory, foreign merchant ship is considered an extension of the territory of the country which it belongs. For this reason, an offense committed on the high seas on board a foreign merchant vessel is not triable by our court. So again, you determine the citizenship of the ship according to its registration. So if it's not registered here in the Philippines, then of course you try it to the country where the ship is registered. Offense committed on board a foreign merchant vessel while on the Philippine waters is triable before our court. But this one, okay, this is the first one is applicable if it is beyond the waters. Okay? But since the Philippine territory extends to 3 miles from the headlands, when a foreign merchant vessel enters the 3-mile limit, the ship's officer and crew becomes subject to the jurisdiction of our courts. The space within 3 miles of a line drawn from the headlands, which embrace the entrance to the Manila Bay, is within our territorial jurisdiction. Okay, so kung nada na yan within 3 miles from the headlands of our territory, then all of them, even if registered abroad, if a crime has been committed on board that ship may ginpatay, it is triable still here in the Philippines. Rules and jurisdiction over crimes committed in merchant vessels. So the French rule, such crimes are not triable in the courts of that country unless their commission affects the peace and security of the territory or the safety of the state is endangered. However, the English rule, such crimes are triable in the country unless they merely affect things within the vessel or they refer to the internal management thereof. So these are rules being used to determine. So, Also, Article 3, acts and omissions punishable by law are felonies. Felonies are committed not only by means of deceit, but also by means of culpa. There is deceit when the act is performed with deliberate intent, and there is fault when the wrongful act results from imprudence, negligence, lack of foresight, and lack of skill. Okay? So what is mistake of fact? Now, what about mistake of fact? Mistake of fact is a misapprehension of fact or on the part of the person who caused the injury to another. Okay. The example cases here, People versus Formaran, US versus Achong. So what are the requisites of mistake of fact? That the act done would have been lawful had the facts had been as the accused believed them to be. That the intention of the accused in performing the act should be lawful. That the mistake must be without fault or carelessness on the part of the accused. Okay? So, here for example, US versus Achong. Achong was new to Manila. So he was very scared of Manila and he had a board mate, sorry, a flatmate. So his flatmate actually went out for something. And then in the middle of the night, because Achong was really scared, no, scared uh um of of the environment in Manila. So usually he would be very cautious. He would be very cautious in opening doors. So that time, no, he heard a loud banging on the door that night. He heard a loud banging on the door, and then when he heard that, he said, "If you come in, I will kill you. No, don't come in." So he actually said that. So, but then that person who was trying to enter, um, was trying to enter, was able to enter. And then Achong, because he was really scared, he himself performed the blow that actually killed that person, who turned out to be actually his flatmate or boardmate. No? So there was a mistake of fact. The first one, that the act done would have been lawful had the facts had been as the accused believed them to be. Because at that time, Achong actually feared that there was a burglar who was about to enter their house. Number two, that the intention of the accused in performing the act should be lawful. So here, it is justified. It could also be considered as a justifying circumstance because if it was an actual burglar who entered the house, Achong had every right to prevent entry or to repel the burglar. Okay? And number three, that the mistake must be without fault or carelessness on the part of the accused. Because actually, Achong said that, do not come in. If you come in, I will kill you. So there was actually sufficient warning upon the person trying to come in that if he does that act, if he tries to come in, he will be killed. No, so there was actually the court considered no fault nor carelessness on the part of Achong of killing uh his his flatmate due to the defense of mistake of fact. Mistake of fact is an absolutory cause. Okay? So, sige. Criminal liability shall be incurred by any person committing a felony, although the wrongful act done be different from what he intended. Okay? By any person performing an act which would be an offense against person or property were it not for the inherent impossibility of its accomplishment or on account of the employment of inadequate and if ineffectual means. The first one actually is by any person committing a felony, although the wrongful act done be different from what he intended. There was a mistake, a blow. No, for example, um, but they're still criminal. Mistake of fact is an absolutory cause. It means that there could be no criminal liability. But mistake of blow is not an absolutory cause. For example, there was a case before wherein there was an altercation between two persons. Nag-away ang duha nga tawo. So, A, because he was so angry at B, he punched him on the stomach without realizing that B actually just had surgery. Okay? Surgery for his stomach. So because of that punch, B was hospitalized, no? Was hospitalized and thereafter died due to infection. So what is the principle here? He who is the cause of the evil cause is the cause of the evil cause. Who is the cause of the evil cause is the cause of the evil cause. Okay? So by any person committing a felony, although the wrongful act done be different from what he intended. So the proximate cause actually of the death of the Abbi is the blow carried out by A. Okay? Number two, by any person performing an act which would be an offense against persons or property, were it not for the inherent impossibility of its accomplishment or an account of the employment of inadequate or ineffectual means. Okay? So this one is an impossible crime. No? So for example, you wanted to kill someone, so you bought poison. But it turned out that the poison you bought was just sugar. So you had the intent, no? You had the intent to kill the person. You administered the poison, purportedly poison to that person, but the person did not die. Was the crime consummated? Yes. You had the intent and uh you gave it to the person did not die. It was still an impossible crime. So, but take note, impossible crimes only refer to crimes against persons or property. So, what are crimes against person? Parricide, murder, homicide, infanticide, abortion, duel, physical injuries, rape. So, if you wanted to poison your husband, but he was not killed because you actually administered sugar instead of poison, but all the acts necessary for the commission of the crime were thereby um, executed. It's just that you used ineffectual means, no? So this is you could be considered liable for the impossible crime of parricide. Okay? Felonies against property, robbery, brigandage, theft. So for example, you stole the watch of your friend, but it turned out that the watch of your friend is actually a watch that was stolen from you a month ago. So technically, the watch is yours, but then you stole it. Take note, in theft, the taking of a personal property already without force or intimidation is also already considered theft belonging to another. But then it turned out that the watch is yours, but still it is still an impossible crime because your intent was to take the the property of another person. Okay. You did not know at that time that it was actually your watch. But then when you turned it over, you were able to actually see your name on it, engraved on it, and you say, oh, this is my watch. But then again, there's already an impossible crime of theft. You stole something that was yours in the first place. Okay. So anyway, we will stop our discussions until there. No? Until there, the coverage of your exams will be until there. So for the meantime, that's it for our class. And I will be sending you our our attendance for the day. Please just wait a few moments while I generate our QR code. So please fill out your attendance through our QR code. Okay. So wait for 2 minutes and the QR code will be generated through this video as well. All right, so I will now be posting our QR code for our attendance this afternoon. So make sure that you fill out our Google Forms. So this will serve as your attendance. So that's it for today. Class, good afternoon, and I hope that you were able to fully comprehend all our discussions on the basic principles and the first few provisions on the revised penal code and criminal law one. So that's it for now. God bless and good luck on your exams.